We interrupt this program for a 5 on Your Side special report.
The ceremonial courtroom is now in session pursuant to adjournment. The Honorable Thomas Chapman presiding. Ladies and gentlemen, please be seated.
Thank you. You may be seated. All right, we're here this afternoon in the matter of Attorney General Andrew Bailey versus Kim Gardner, Circuit Attorney for the City of St. Louis, case number 2322-CC00383. Before we get started, are there any preliminary matters?
Judge Michael Downey from Ms. Gardner, I presume you saw that we filed a motion to dismiss and motion to shorten time about an hour ago.
I have not seen that yet. I understood there were some developments.
Corey, do you have copies of you now?
Okay, I'm sorry, I can't hear you.
You give an extra?
Yes.
And Judge, in conversations with opposing counsel, as you'll see, Ms. Gardner by email notified the governor that she was assigning prior to this, or that she was resigning prior to this hearing. So I think that's probably going to shift everything else that's going to happen at this hearing today.
Thank you. I understood something was going on, so that's why I started with that. Why don't we go ahead, now that we have that preliminary matter out of the way, and let's go ahead and announce the appearances. First of all, for the Attorney General relator.
Bill Corbett for the state of Missouri, Your Honor.
Thank you.
Greg Wood for the state of Missouri.
Natalie Warner for the state of Missouri.
Andrew Clark for the state of Missouri. Sean McElroy for the state of Missouri.
All right, thank you. And for the respondent?
Michael Downey from Ms. Gardner.
All right.
John Serber, also FedEx for Ms. Gardner.
All right.
And Paige Tungate for Ms. Gardner.
Paige, say that.
Paige Tungate.
Thank you.
Bob Bunker for Natalia Okerkowitz, judge, responding to his subpoena.
Yes, thank you.
John Jeffers, Tony Miles, Nicholas Cooper, on behalf of the office, the Circuit Attorney's Office, Your Honor. Good afternoon.
Thank you. Anyone else?
Booker Shaw on behalf of the judges of the 22nd Circuit.
Thank you. Any other parties or non-parties that have a counsel present?
Judge, I can see Veronica Johnson is on. She's counsel for the Family Care Health Centers.
All right. I'll note that. All right. I guess the motion to dismiss has been filed. Do you want to just address that first, or how do you have an intention how to deal with that, Mr. Corrigan?
Sure, Your Honor. I think that makes sense. I may please the court.
Certainly.
About an hour or so ago, Ms. Gardner's legal team filed a motion to dismiss the quo warranto matter based on her resignation. We received word about an hour and a half ago that Ms. Gardner was resigning effective immediately, and we've seen the email, and I provided it to the court. There's an email exchange. There's an email from at 11:31 this morning from Ms. Gardner to the governor's office indicating her intent to resign, and then one at 11:47 clarifying that and indicating that she was resigning today, effective immediately, and that she is no longer the circuit attorney for the city of St. Louis. A short time later, we received her legal team's motion to dismiss, along with a motion to shorten time to have the motion to dismiss heard. The state has no objection to having the motion heard today. I told Mr. Downey, as a courtesy and to be transparent, that in light of the situation, what we would ask is, I think there's a high likelihood that these proceedings are moot. However, there is currently not a circuit attorney in place. My understanding is, and the latest information that I have, is Mr. Wesley Bell was appointed as an assistant circuit attorney by Ms. Gardner before her resignation. She does not have the ability to appoint him as circuit attorney, as you well know, and that Mr. Bell is interested in serving as a circuit attorney and is in communications with the judges of the circuit, who are represented today by Judge Shaw, and he's in communication, we understand, with the governor's office. So obviously this is a very unprecedented situation, and a very evolving and fluid situation. And so in my judgment, what makes the most sense for the court's consideration, and I mentioned this to Mr. Downey before we began today, is the state's position is that we believe it would be best to defer ruling on this motion, to reset this for hearing next Monday or Tuesday until we see what happens later today in terms of the appointment of a circuit attorney. I think we'll have more clarity on the whole situation, and that I think in the interest of economy and just to be prudent, that we ought to defer the hearing on the motion. And if a circuit attorney is appointed in the next, either later today or shortly, I think there's a high likelihood that the motion, that the state will not contest the motion, and there may not even be a need for a hearing next week. So that would be my counsel for the court's consideration, Your Honor.
Thank you, Mr. Corrigan. Mr. Downey?
Your Honor, I'm not sure if Mr. Corrigan made it clear, but it was my understanding also that you were okay with all discovery being stayed. The state is fine with all discovery being, under the circumstances, well, you know, again, we were prepared to argue all this short, but in light of what's recent developments and rather dramatic developments, frankly, the state is fine with deferring all discovery until we see what happens the next few days. And Your Honor, I'm actually trying to get final consent from my client on this, but I think, frankly, the course of action they're proposing is a reasonable one. That we stay all discovery, which obviously there are depositions noticed up for the next couple of days. There are pending subpoenas. All of that will just be stayed, and then we'll wait until we have some sort of interim circuit attorney, and then go ahead and let the case be dismissed.
So would it be acceptable to the parties that I just take the motion to dismiss under advisement for now?
Yes, sir.
And we could pick a day early next week to have a hearing, and then maybe Tuesday, so that would give the state the opportunity to maybe file its dismissal or its consent to sustaining the motion to dismiss, whatever you wish. And so maybe Tuesday next week. I got to look at, I think that would work for me. Would that
Yes,
work?
That makes sense. And again, I think there's a reasonable likelihood that we will not need to have that hearing, but I think scheduling for Tuesday makes perfect sense.
And Judge, you have two pending motions to stay, one that was filed by Ms. Gardner and one that was filed by the Circuit Attorney's Office. I think effectively granting either or both of those will stay all the discovery.
All right, so I will sustain, you know, the state's motion to stay the discovery, and I will take the motion to dismiss under advisement. We'll set the matter over for I guess we'll just call it another status conference, and if there's anything changed, I won't rule on that motion to dismiss until the status conference, but maybe things will be finished before we even need to have that. So why don't we do that, and we'll just set it, what is Tuesday? Next Tuesday is the 23rd. So let's set it for next Tuesday, the 23rd at 1:30 p.m. for a status conference on that date. And I would ask somebody just to prepare an order memorializing what we're doing here today. Mr. Corrigan, why don't you prepare that and have Mr. Downey review it and then send it on to me, and we'll do that.
Excuse me, Judge, I believe you're in Kansas City. Are you based in Kansas City?
I am. That's where
I'm actually going to be in California next Tuesday.
Okay.
So I asked that the hearing, I think we could probably do it virtually.
That's fine. That's fine. We can do that for the persons that need to appear virtually.
And you're okay with just a handwritten order for today, aren't you, Your Honor?
Excuse me?
Are you okay with just a handwritten order today?
That's fine. That's fine. Or if you wish, you can submit it before the end of the day.
We'll do that.
We just submit something written just to kind of memorialize what we did here today. That would be fine. And anything else that we need to address today?
Judge, my understanding is in the depositions and document production based on schedules will be to be determined in the future.
Would you state your name?
Yes, Bob Unger, Prince Heidelberg, was there's a subpoena issued to my client, so what I want to make sure any deposition date, any date of production is now stayed, and that will be determined at a later date.
I would, yes, I think that there were motions to quash, and I would assume that the parties will withdraw their motion, their subpoenas, or at least agree to continue them and reset those subpoenas or reset those deposition dates in the meantime.
We will reset now.
Okay.
Understood, thank you.
Thank you. Anything else today?
No, sir.
All right. We will adjourn. Okay.
All rise. The ceremonial courtroom will be in recess to next Tuesday. Ladies and gentlemen, thank you for your attendance and have a great rest of the day. You may leave the courtroom.
This has been a 5 on Your Side special report. We now join regularly scheduled programming in progress.